Okay, good afternoon. Thanks for joining. My name's Stuart Roberts, as I guess you've worked out by now. I'm a member of the employment team at Park Lane Plowden. The employment team, I should mention, there are about 30 of us, I think, in the employment team, spanning the full range of experience and also spanning both Leeds and Newcastle. And members of the team cover cases pretty much wherever. And this is a case in point. This was a case in Exeter, an in-person case in Exeter that I'm going to address. As for myself, I've been at the bar since '94. I started doing employment work, in fact, before I was called, when I was doing my CPE, trying to turn my medieval history degree into something more useful. I started working for a free representation unit down in London. And so through conversion course and bar school and first 6 months of pupillage, I was doing cases, including employment tribunals, via the free representation unit. So by the end of my first 6, I think I'd done about 20 contested trials in the tribunal, including, in fact, a 6-day trial I did in my first 6 against someone of 22 years cool. I could barely believe anyone was that old when I was that young, but of course I look back and I think, oh, 22 years cool, that must have been nice. I remember that. Anyway, my background started from the outset doing employment. Once I came to the bar, I spent most of my time in about the first 12 years doing serious crime in the Crown Court. So that means I'm someone who is completely at ease in court or tribunal cross-examining people, including cross-examining people about very serious things like sexual offences and sensitive matters. But it also means that even though I've spent the last about 17 years as a civil and employment specialist, and I haven't touched any crime at all in that period, I still am someone who loves to roll my sleeves up and go for a good, messy, contested trial. Nowadays, I am a Chancery commercial and employment practitioner, so I span in the employment field. I span all types of employment work, and I'm, as it were, particularly suited to dealing with anything where there's a crossover between employment and civil work, such as injunctions, springboard injunctions, restrictive covenants, contract disputes arising from the employment contract, shareholder disputes, which are very akin to employment disputes at times, and so on. I have that overlap where I cover both. So I'm familiar with the CPR and all the court rules, and I'm obviously familiar with employment law. Anyway, that's me. This is Law with Lunch. This is an occasional series. I think they are done about once every 2 months, but I'm not entirely sure how often. Obviously, the idea is to make it easy for people logging in to absorb a bit of legal knowledge or experience whilst eating your quinoa salads, whatever it is. So some of these talks are obviously much more really helpful. They're telling you about a new legal development or an important piece of case law. This is more akin to, as one of my colleagues called it, a fireside chat. I'm going to be talking through an actual trial and some of the pitfalls, problems and opportunities that arise going through. Now let me see if I can make this work out. There we go, good. The case I'm going to talk to you about is Annette Plout and Exeter University. Why have I chosen this case? Well, for a number of reasons, really. It was flipping difficult. The client, I have to say, it was very difficult. I was for the claimant. She had got herself into difficulties at work because she was alleged to have been shouting at people. she was, putting it neutrally, very loud indeed, particularly in the small conference room, and indeed also in tribunal when giving evidence. It was a memorable case in lots of ways, partly because of what was at stake for her as an academic who'd been who'd been dismissed, and the issue was whether she'd been unfairly dismissed by Exeter University. So it was very important for her, and I have to say it was one of those cases where I was very keen to win, because having been dismissed, realistically, this was likely to be the end of her career. She was, I think, 58 at the time. She was quite a specialist in terms of her expertise as an academic. She was a physicist in the physics and astronomy department at Exeter, and had been there since 1990. And the reality is, in a small world like that, if you've been unfairly dismissed and you're 58, it becomes almost impossible to get another post. So it was a good case. It was a satisfying case because, as you might have guessed, we were successful, as the Guardian reported, and it was also quite high profile. It was reported in the Guardian, on the BBC, and various other places, ranging from the heights of the Times and the Telegraph to the Mirror and the Star, and it was reported in the Jewish Chronicle, the Times of India, TLS, and various other places. So it was one of those cases that catches the attention of the press and suddenly becomes slightly higher profile. And I suppose there are various reasons for that. These cases don't crop up very often, at least not in my experience. In the world of schools, certainly since academies have come along, in my experience, there's been a great increase in disciplinary cases, dismissals, where academies have basically become more ruthless, I think, about cutting out what they see as dead wood. At times, they're prepared to put their hands in their pockets and settle cases, or dig their heels in and fight them. Either way, they think it's worth it to try and get rid of, as it were, underperforming teachers who otherwise had a job for life. To an extent, I think the same is maybe starting to happen in the world of academia. Academia has become such a business nowadays, whereby universities, they have huge budgets. They attract large numbers of overseas students who get charged maybe double or more what the domestic students get charged. And they're all vying with each other to fill those places. Against that background, if they have a member of staff who generates complaints, they are becoming more likely to take severe action, including dismissal. And that's an observation of mine. It's more anecdotal than anything else. After I dealt with this case, and after it was fairly widely reported in the press, I got a number of inquiries from other academics who were in similar-ish situations. None of them ended up in a big shootout at the OK Corral like this one did. But certainly there were a number of people who identified with this case being in a similar position. So there's a bit of a summary in the reports there from the BBC News and the Guardian. I've included details in the slideshow of where this case is available, obviously on the government ET website. There are 3 judgments. First is on liability, because it was a liability-only trial. Second is a judgment, which I'm not going to go into, where the respondent sought reconsideration on various points. That was rejected. and there was a judgment in relation to remedy. So the claims: Dr. Annette Plout, she was a senior lecturer in physics and astronomy in Exeter, and she was the only academic in that department when she started in 1990. The only woman in the village. She was dismissed on the 30th of January 2020 after almost 30 years of service. And as I said, it was always likely to be hard for her to get another post. That has transpired to be the case. As I understand it from my solicitor, the position is that she still hasn't been able to find another post. And she was talking about simply taking retirement if she couldn't be reinstated. But she also has a wealth of knowledge and wanted to continue in academia if she could. She is British Jewish from a German Jewish family, and that is a relevant factor in this case, or certainly was on her case. Another few details about the claim, which I haven't set out on the slide. She's a single lady. She lives on her own in Exeter. She had moved there from London many years ago for this job. And I think it's fair to say she's not the most socially skilled of people. She had lots of friends in the university, but few, if any, friends outside the university. And that became very relevant when she was suspended in relation to actually 2 periods of suspension, but they both ran into each other, on terms that she was prohibited from contacting colleagues. She also was a very passionate teacher, very passionate in terms of her supervision. She would supervise PhD students, so she would have a small number of PhD students. She was involved in research and was involved in some lecturing and producing research material and papers. There were 2 claims which were conjoined. The first one was initiated in January 2020, just before her dismissal. So this was after her disciplinary hearing, but before a decision had been made, or at least before a decision had been communicated to her. The first claim involved claims of race and sex discrimination, harassment and victimization. She complained of a raft of things which she said were discriminatory or amounted to harassment or victimization. The key ones were that she was suspended on 2 occasions, although they ran into each other, that she was disciplined for a matter which she said was not one which merited a disciplinary procedure at all, and in due course she was to complain that her dismissal was amounted to race and sex discrimination. The race discrimination was based on her Jewish ethnicity, and obviously the sex discrimination based on the fact that she was a female. Initially, the only female in the department, she said she had always faced an uphill struggle, resistance from the hierarchy and from some colleagues. But in particular, she said that the combination of her Jewishness, coming from a Middle Eastern Jewish, Middle European, Jewish background, German Jewish, and being a female, she said her background made it normal for everyone to speak very loudly and to be very expressive with gesticulations and forceful in their arguments. And she said the fact that she was a woman who would speak loudly and speak in a very forthright way in terms of her opinions. She said the fact that she was a woman was never accepted by people. So she kind of relied on a combination of those 2 things together. Unfortunately, the law doesn't really help her there, because what she continually argued was an intersectionality, which is what I didn't like, of those two things, is not recognised in the Equality Act. Anyway, the long and short of it was, she said she had a loud voice when she was impassioned. She was impassioned about teaching physics, but that led to complaints, and people would complain not just that she was loud, but that she was loud and shouting at people, including students, including in one-to-ones and two-to-ones, and also that she was criticised for being negative and putting people down, whereas she would say, well, this was me being passionate, trying to get the right answer. So that was the first claim. The second claim was issued in June, claiming unfair dismissal for the grounds set out there. And importantly, the claimant sought reinstatement. She was adamant that she wanted reinstatement. Before I was involved in the case, she was told fairly clearly via a directions hearing that reinstatement is rare, but that was what she wanted. And one could understand that, because this was her passion, and it was also the best chance of her being able to get a job was being taken on back in the department. The university was dead set against it. They said, whatever is the outcome, we're not going to reinstate it. Anyway, so key facts. This dates back to an incident which appeared to have happened in 2016. So with one of her doctoral students, she had 3 students at the time. Student 1 ended up making a complaint about her. Student 2 subsequently made a complaint about her. Student 3 made no complaint and was positively complimentary about her and her teaching. But the incident with student 1 ended up being an allegation that the claimant had held her neck and shone a bright light into her face. And it was alleged that she had sort of held her head using the back of the neck and put a lamp in her face in order to explain to the student some principle which I'm not sure I understood at the time, so I'm not going to go into. But it was some physical principle that the student wasn't understanding and that the claimant wanted to explain. The same student also made complaints that Dr. Plout would shout at her, that she was aggressive and very critical, very negative, and, for example, would dismiss parts of her work as being rubbish. Part of the difficulty about all of this is that the matter wasn't mentioned, it seems, by student 1 until November 2017. And it appeared, it wasn't clear from the papers, because it was a bit of Chinese whispers, but it appeared that the complaint was about something that happened in 2016. So it was perhaps a year later that a complaint was made. It was raised by the student informally with her new supervisor. So there had been a change of supervisor, or a new second supervisor, I think it was. So she was speaking to her new supervisor and reported this. And the new supervisor, or the second supervisor, reported to the head of department. The head of department didn't do anything at all about it. In the following year, in August, there was a change of the head of department. So a new head of department in physics. And the new head of department, reading between the lines, didn't like Dr. Plout and thought she was trouble. So it's reported onto the new head of department in August 2018. That eventually crystallizes in a complaint being made in a formal way by the student the student didn't want to make a complaint. But eventually this is initiated. An investigation was started, I think, in November 2018, but nothing really happened until January 2019. So already we're talking about an incident that appeared to have happened in 2016. The claimant is suspended in January 2019, and the suspension was questionable, one could say, putting it mildly. Why? Because it was at least 2 years down the line, it looked like, and there wasn't any explanation for why a suspension was needed. In the meantime, Dr. Plout had continued to teach, and she had continued to teach student 1 for a number of months after the incident, possibly about 9 months, without any more complaints or anything else that student 1 particularly complained about. And since then, they had both been in the same department. They would come across each other without any difficulty. And there was no other reason to suspend her. So it seemed over the top and unnecessary. And one can imagine the impact upon someone in Dr. Plout's position, a very experienced, very senior academic in the department, suspended. This was, to a large extent, her life, her working life and her social life, all involved the university. And the suspension was on terms that she wasn't contacting the other colleagues. And that hit her very hard, as was apparent. The investigation ended up in a disciplinary action. Unfortunately, it's not quite clear why this happened, but the letter saying come to the disciplinary hearing alleged she'd shone a laser in the eyes of student 1. So Dr. Plout worked with lasers, and she was quite clear that you wouldn't shine a laser into a person's eye because it would potentially blind them. And this was obviously just nonsense, and it transpired that it was a mistake that had somehow crept in. It was pointed out, but the respondent just stuck to it anyway for reasons that weren't clear. The disciplinary happened in February 2019. The outcome letter came in March 2019. The decision was that this was an instance of gross misconduct. And she was given a final written warning to be effective for 18 months. Pausing there, I didn't think there was any basis for challenging the conclusion that this was gross misconduct, even though that decision was made on the basis that it clearly wasn't a laser. So the disciplinary hearing was clear that the allegation was simply that she'd shone a lamp, desk lamp, into the student's face. Even so, on that basis, the allegation probably did amount to an incident of gross misconduct, or something that could be found to be gross misconduct, and probably not such as to merit dismissal, because it seemed to be something of an isolated incident. There was a history, including a number of incidents in previous years, where there have been complaints to some extent or other, mostly informal, about Dr. Plout basically shouting at people or being overly loud at people. But there'd been nothing that really crystallized in anything significant. So a final written warning, and this was something that she didn't dispute, she didn't appeal, and so that effectively formed part of the background, or a big part of the background to the case as it proceeded. The outcome letter included some mandatory steps. So she said in her defense, well, I am loud, everyone knows I'm loud. And there has been this issue that's popped up in the past, and it's been agreed that HR can tell people that I'm naturally loud, and it really doesn't mean anything. So people shouldn't be upset by it. It's just how I operate, it's just the way I She hadn't had any sort of assistance, as it were, to rectify this problem. And so there was included in the outcome letter a number of mandatory steps that should happen. She was required to cooperate with these things, but she was fully willing to do that. To have some refresher training in equality and diversity, some voice training and or coaching in speech and body language, which potentially would have been really useful for her, and regular monitoring by and progress meetings with the head of department. That is understandable and sensible on the face of it, but unfortunately was likely to cause difficulties moving forward. Anyway, the outcome letter was in early March, 12th of March. And obviously, as a result of that, her suspension should come to an end. It didn't actually come to an end. No one did anything about it. No one got her back into work until a return to work meeting on the 3rd of April. And of course, even if she was not to come in to the premises, she could have been given work to do that she could do from home, or that she could do in a way that wouldn't have her interacting with any of her PhD students. But nothing happened. There was a return to work meeting on the 3rd of April. Unfortunately, that went rather badly. Both she and the head of department became angry. He made a comment to the effect that, well, no one can criticize me in terms of diversity and inclusiveness. And she said effectively, well, I can. And she insinuated that he was at least unconsciously biased. As a result of that unfortunate outcome in the return to work meeting, she didn't return to work, and she was suspended again on the 12th of April, so 9 days later. But so this is a month after the first disciplinary outcome letter was sent out. In the intervening month, she hadn't gone back to work. So in de facto terms, she continued to be suspended all along. And again, she wasn't allowed to contact her colleagues. In the interim period, in fact, there had been a report from occupational health, which identified that she was very much struggling because she was isolated, and it was or could potentially affect her mental health. So it was recommended that that condition not apply, or she be able to identify various colleagues that she could liaise with. Nothing was done about that. That wasn't implemented, which was very unhelpful. And the reality is that she then remained suspended again until her dismissal. I haven't given every step of the detail here because we've only got an hour, and I'm planning to not take a whole hour anyway. As I said, she had 3 doctoral students. During the course of this first investigation with student 1, she'd said, look, I get on with my other students, there's no problem. And student 2 in particular, she said, well, look, at Christmas, he brought me a card and gave me a box of chocolates. And the other one was complimentary about her as well. She said they were both complimentary about her. So she's now suspended again. The head of department has a meeting with student 2 because he's obviously been missing his main supervisor since the suspension in January. So this is in, I think, April. And during the course of this, which was on the face of it a meeting to discuss how to proceed, given that he had a supervisor who was suspended, although he didn't know that, student 2 thought she must be ill. There was another complaint that arises. The claimant said, well, this has been generated by the head of department, he's out to get me. But that wasn't something that the tribunal eventually concluded. But anyway, it did feel a bit like that, because this complaint seems to come out of the blue a bit. He hasn't made a complaint in the intervening period, and indeed he hadn't been supervised by the claimant in that year because she'd been suspended. So the last time they dealt with each other was back in just before Christmas, which is when he bought her a card and a box of chocolates. And in fact, as the evidence came out, they had a disagreement. She was unhappy with him because she felt he was not showing her what his research was and where he'd got to, because he was worried about criticism. And they had a sort of heart-to-heart about it. They had this out, and he agreed to show her all his research. And he said he understood that, you know, she may seem critical, but she was striving, you know, she was striving for the best outcome that could be achieved. And it was in that context that there was the card and the box of chocolates. So this came out of the blue, and it certainly came out of the blue for the claimant. And importantly, it related to a period before she'd been disciplined, and therefore before she'd received a final written warning. Unfortunately, student 2 wasn't really keen to make a complaint, but he was told, not by the head of the department, but by another of the academics, that he had to follow a complaint procedure in order to change his PhD supervisor. This wasn't the case. The first student had simply changed supervisor without making a complaint. So that seemed to be very unhelpful, unattractive, and of course made someone like the claimant very suspicious of everything. The allegations from student 2 weren't anything as clear-cut as grabbing my head and pointing a lamp in my face, but it was more general, a complaint that she would shout at him, and that at times she was very negative. This crystallized into an allegation of frequently shouting at him, causing him stress and anxiety. The second part of that was always very thin, and there were suggestions in relation to both students actually that they had been mentally adversely affected, but there was simply no evidence to support that. There's certainly no medical evidence. Anyway, during her suspension, she'd been told that she was facing disciplinary investigation in relation to the matters that happened at the return to work meeting. But that then got dropped. And the focus was on two things, actually. I haven't set out the other thing in the slides, but one was frequently shouting at student 2, causing him stress and anxiety. And the second one was a complete breakdown of relations between her and the head of department on the one hand, and the head of department's line manager, Mr. Evans, with whom, in fact, the claimant never had any dealings with at all. So, of course, that always seemed a bit tenuous, because how can you have a complete breakdown in relations if there are no relations? And with regards to the head of department, even though the relationship was difficult, in fact, his response immediately after the return to work meeting was he wanted to record it, he wanted to mark it, because he didn't want this sort of thing to be happening again. But he indicated that he didn't think it was a matter that needed to be taken further. So against that background, it was hard to see really how one could sustain a complaint against her of a complete breakdown between her and the head of department. He hadn't said there was a complete breakdown, and quite the opposite. Anyway, there was an investigation report carried out, and that was done by October 2019, which is, again, a fair way down the line, bearing in mind the claimant was suspended. That recommended dealing with the matter outside the disciplinary process. It acknowledged the complaint and didn't suggest that it was not made out, but it effectively suggested that this was not so serious that it needed to be dealt with in a disciplinary hearing, and rather the more important thing would be to try and build bridges between the claimant, and in particular the head of department. That report was effectively overruled by the head of HR, who ordered a disciplinary. So there was a disciplinary in December 2019 that was heard by a vice-chancellor, unconnected with the physics department. During the course of this, she had very supportive evidence from two colleagues who were not just supportive, but incredibly supportive. One of them had been a colleague of hers for 25 years and was effusive in his praise of her, saying that she was had a tendency to get very passionate, that she was someone who desperately wanted the best outcomes for her PhD students, and that for some PhD students, often the ones who were slightly less achieving, where other members of staff maybe gave up a bit, that she was fantastic. That she was very sympathetic in terms of students if they had personal problems that arose, that she went above and beyond in terms of her commitment to the job, in terms of the hours and research, and so on. So there were lots of positive material before the disciplinary hearing. But in any event, the hearing did its job and went away to consider matters, indicating that it might need to make some further investigations. And then on 30th of January 2020, the claimant was dismissed. The outcome letter held that it was particularly based on the incident with Student 2. It was found that that was misconduct, but not gross misconduct. However, due to the existence of the final written warning, the outcome was one of dismissal. That was even though this was nothing more than shouting and negative comments at its highest, and she obviously disputed that, even though that she had never, in fact, returned to work from the date of the first suspension, and she hadn't gone through the training that had been suggested as being important in the first disciplinary outcome. And even though the first disciplinary report here didn't recommend any disciplinary proceedings, so she was dismissed. She appealed. Unfortunately, the timing was such that she appealed on the 30th of January. It was originally planned to be heard in February 2020, but as we all know, the original hearing didn't happen for various reasons. COVID intervened in March 2020. There were various problems on both sides. Eventually, the appeal got heard in, I think, about March 2021, and the final rejection of her appeal was in June 2021. So by that stage, she had been dismissed for almost a year and a half. Again, that was heard by a different vice-chancellor, not connected to the physics department. So one of the key developments in this case was a freedom of information request. She made a freedom of information request of her own basis for all information relating to disciplinary proceedings and dismissal. And the outcome was gold dust. There was, after the disciplinary hearing itself had finished, there was a whole range of interactions between HR, one of the witnesses called by the university, PV, I've called him, and the disciplinary panel itself, including the head of the disciplinary panel. PV was absolutely gunning for Dr. Plout. He was adamant she should be dismissed. He didn't have complaints himself about her, but he said he'd witnessed her shouting at students and staff, bullying people, reducing them to tears. And he laid it on with a trowel in these emails that popped up after. They weren't the subject of the disciplinary hearing at all. There weren't allegations that were ever presented to her or that she was ever given a chance to answer. But they were accepted by the by HR and at the head of the panel. There were emails thanking him for his candor and all the rest of it, and saying that, you know, we'll have to take these into account. Astonishing, I thought. And also, student 2 was then questioned by the panel. Indirectly, that was done by HR, but secretly, the claimant was represented with the union at all times. This was done effectively behind their backs, without telling them anything about it at all, and without giving them any inkling of either the fact that the questions had been asked or what the answers had been given. Unsurprisingly, all of that was found to be completely improper. So, my involvement, the case had been started some considerable time before I was involved. I was instructed on the 4th of October 2021 for a trial starting on the 15th. An 8-day in-person trial. I think the first day was reading day, down in Exeter. And there was masses of material to try to get through. I really wasn't helped by the fact that the papers obviously came very late. They were very voluminous, and the claimant herself completely rigidly wanted to focus on whether it was right to say that she shouted. She was absolutely furious about the allegation that she shouted at people, and she just said, "No, I'm very loud," and she wanted to defend the fact that she was loud based on her Jewish heritage and coming from Middle European stock. She put in, or tried to put into the bundle, lots of articles about Jewish people being loud, and/or females who were strident being penalised and disciplined for it. All of which was largely irrelevant and inadmissible. But anyway, so I got the brief very shortly before trial. In fact, I think on the 7th of October there was a CMO, but I wasn't even made aware of that because it was so late. I hadn't even finished reading the papers. I hadn't even been sent all the papers by that stage. And the solicitor did it herself. The trial itself did feel a bit like University Challenge at times. I was there with the claimant. The solicitor wasn't in attendance. She was funding this by way of legal expense insurance that she was lucky enough to have in place. So DAS and DAS Law were representing her. They didn't stretch to having someone in attendance for me, which made things very difficult because the claimant was the sole witness for herself. University called 9 witnesses. So I had the very difficult task of trying to cross-examine people about 1,200 pages of evidence, and trying to make notes of it as I went along, and or trying to make notes of it as soon as I sat down. And the reason I didn't mention University Challenge is because of the 9 witnesses called by the respondent, there were 2 vice-chancellors who'd taken the decision to dismiss and the appeal decision, and 5 professors. It was a very high-powered group, and at one stage, I think the tribunal chairman, Mr. Houseco, commented that he'd probably never been in a room with as much brain power. It was heard, obviously, being a discrimination claim by a full panel. The outcome, I've said perhaps it was a score draw. The ET judgment came out fairly promptly, but all credit to them. We were successful in establishing unfair dismissal. And I have to say, I always regarded this as above and beyond everything else, an unfair dismissal case. And we had the obvious strong points that she'd been an academic for a very long time. She effectively had a very good record, apart from the incident with student 1. She hadn't had the opportunity to go through the training and voice coaching or whatever else that had been suggested in the first disciplinary. And the second matter wasn't a matter of gross misconduct. On one take, based on the original investigative report. It wasn't a matter of misconduct at all. But even if it was, it on its own was never a sacking matter, as the tribunal found. The only reason it was elevated to something leading to dismissal was because she was subject to final written warning. But that did seem to be inherently unfair, given that she'd not done anything whilst the warning was in place. And further, she hadn't had the opportunity to undertake the training that had been part and parcel of that warning. Anyway, but added to that, we had the cream on the cake, which was all the shenanigans behind everyone's backs with the disciplinary hearing. And unsurprisingly, it was found that the dismissal was 100% unfair. We also emphasised things like the fact that the suspension of itself was screamingly unfair. She was suspended for an inordinate amount of time, where there was no allegation that she was up to no good. During the period of suspension, there was an office move, so she was back in with the agreement of the respondent, at the request of the respondent. She was back in and moving office, which took about 3 weeks, without any incident at all. So she would and did bump into both student 1 and student 2 without any incident. So the suspension, certainly for such a long period of time, seemed wholly unjustifiable. And there was just a bad smell about the whole thing as well, because one did get the impression that the head of department was slightly gunning for her. The fact that the first investigative report did not recommend disciplinary proceedings, but that was overruled effectively by the head of HR, and the head of HR was one of the people who was involved in the cabal, which went ahead after the disciplinary proceedings or the hearing had happened, but before the judgment came out or decision came out. And also, even though this wasn't wholly the respondent's fault, the length of time taken to deal with the appeal meant that the appeal couldn't rectify any earlier unfairness. The other complaints, there was a claim of harassment and victimisation, which was upheld in relation to the initial decision to suspend after the return to work meeting. The protected act was said to be the assertion that the head of department could be criticised, was not a paragon of equality and diversity. I have to say that always seemed to be a bit of a side issue and not a strong part of the claim. So perhaps I was slightly surprised, but pleased that we succeeded on that. All the other complaints of discrimination were dismissed. The tribunal held, I think unsurprisingly, that whether or not she does actually shout at people, she maintained that she didn't and got very upset about the suggestion that she did. Other people perceived that she was shouting at them. And if matters proceeded against her as a result of that, that's not tainted by race or sex. She wasn't helped by the fact that one of the arguments she raised was that there was a Jewish man in the department and he was loud, she said, and he didn't end up facing disciplinary. The tribunal said, well, doesn't that show precisely that it's certainly nothing to do with race? And there were other difficulties about the race and sex claims. They didn't really stand up to any good scrutiny. Snakes and ladders, at the end of the day, there was a finding that there was a breach of the ACAS code, which seems to me natural given the way the disciplinary was conducted behind closed doors. And but on the other hand, there was contributory conduct on her part, which could have been higher, but was 25%. Those don't completely balance themselves out. Actually, if you do the maths, it ends up at 93.25% or something. But not decisions that I thought were unfair. I thought that contributory conduct could have been worse. The remedy hearing took place on the 20th of December. So again, really quite prompt, given that the original 8-day hearing was in October. We ended up having to have a full day hearing. Total award was just over £100,000, including £20,000 in intervenings. The rest was loss of earnings and basic award. And those were the figures after the 25% reduction, and after applying the cap and after the grossing up exercise. I'm not going to dwell on that, but the round figure was 100,000. And the reason I decided to have a talk about this case now, even though it's quite a while ago, that there had been an indication that the respondent was going to appeal. And I understood that given the passage of time, that had gone away. On Monday, I was told that they have got through the sift. They lodged an appeal on the 4th of January, appeal against various matters relating to liability. They sought permission on 7 grounds, and in fact, the EAT SIFT judge granted permission to appeal on all grounds. That was on the 31st of March. For some reason, that was only sent out to the solicitors on the 12th of June. So, and I was informed about it on Monday. As a result, I've been a lot less candid than I might have been, because this case hasn't finished. It's listed for 1.5 days, sometime late this year, early next year, depending on availability. So, key takeaways. I'm just about to sign off. I was thinking I might just about have time to whiz through this. Looks like my estimate isn't bad. The key takeaways, well, from a personal point of view, I love it if I got instructed a bit earlier. I barely had time to read everything in advance, and the prep that I had to do wasn't finished by the time the trial started. I was up every night until 2 a.m. at least, because I hadn't had a chance in advance to prep all my cross-examination of all the various witnesses. See the wood from the trees. I say that because the absolute dynamite material which had arisen from the Freedom of Information request was not mentioned in the particulars of complaints. It was not mentioned in the voluminous emails and letters that the claimant sent to her solicitors and to me. Pages and pages of stuff raising issues about the intersectionality of race and sex, and that she wasn't shouting and it was very offensive. But missing the fact that actually we had this gold dust material arising from the Freedom of Information Act. And I didn't even get to it for about my first 3 days of reading. And wait until a case is actually finished before doing a talk. Anyway, but above all, the Freedom of Information request, a masterstroke, done by the claimant. The solicitors hadn't suggested it, and it's something that she initiated, and it produced the winning material. Whether the winning material survives the appeal, we shall have to wait and see. But it's 1:28. I think most of you have finished your asparagus and whatever else you're having for lunch. I can't invite any questions because of the way this webinar works. But of course, feel free to get in touch, either directly, you've got my email address, or indirectly via the clerks. Thank you very much for your time. Yes, I wish you all well.